Hello, and welcome to Crime and Court. My name is Heather, and this is another Delphi doc update. So some more court docs have dropped coming from the defense, coming from Richard Allen's team, and a couple different documents happened to come out or drop, be filed right around the same time. So we're going to read those. In my last episode, or my last video about the Delphi documents, we read through the motion for continuance from Bradley Rosie because he couldn't appear in court for the date, the hearing that the judge had set for the information that they're calling it for contemptuous conduct. So this is now another response. This is coming from Richard Allen's attorney, Andrew Baldwin, and he's, we'll just read it. Okay, so he's also asking for a motion for continuance. Comes now the defendant, Richard Allen, by attorneys Bradley A. Rosie and Richard J. Baldwin, and respectfully requests that this court continue the February 12th, 2024 hearing on state's motion to amend information filed on January 18th, 2024. In support of said motion, attorneys Rosie and Baldwin state as follows. Number 1. On January 18th, 2024, the state filed an amended charging information and motion for leave to amend said information. The state's request is to add 4 additional counts to the original charging information. Number 2, on February 1st, 2024, the court issued an order setting the state's motion to amend for hearing on February 12th, 2024 at 9 a.m. Number 3, at the time of filing of the amended information, Attorney Rosie and Attorney Baldwin were not acting as Richard Allen's lawyers. It was approximately 6 hours later that they were reinstated as Richard Allen's lawyers in this case. So they're trying to get them for contempt when they're filing motions to do this when they're not even necessarily on the record as Richard Allen's lawyers. So number 4, as the date of this motion, so when was this motion done? It's blocked. I think it was, was it yesterday maybe? Not sure. Or Friday. As of the date of this motion, attorneys Rosie and Baldwin are in the process of recovering the voluminous, tongue doesn't want to work, the voluminous discovery in this cause. The recovery has involved the transfer of information from attorneys Scremin and Libredo to prosecutor McClelland and then to attorney Rosie's office. That seems very convoluted. They have to get the Scremin, the old attorney, has to return it to the prosecutor, who then gives it to Rosie. Gives it back to Rosie. The discovery must then be shared between attorneys Rosie and Baldwin, whose law offices are separated by nearly 100 miles. 5. In addition to recovering discovery that was previously possessed by attorney Rosie and attorney Baldwin, the prosecutor's office has now directed additional and what appears to be new discovery to attorneys Rosie and Baldwin. What the hell is this new discovery? The new discovery, upon initial review, appears to be quite voluminous and will likely take several weeks for attorney Rosie and Baldwin to review. What the hell are they getting? They were supposed to be in trial already. Back in January, early January. So there is also the difficulty of communicating with their client regarding the new discovery, considering the distance between the client and the lawyers. Bam, we need him transferred to a local county jail. Click it over here. And click. All right, so number 6. Without having an opportunity to review the entirety of the new discovery, and attorneys Rosie and Baldwin have no way of determining whether or not the amendments will prejudice the substantial rights of the defendant. Number 7, attorneys Rosie and Baldwin are private practitioners and therefore have other clients and responsibilities that must be prioritized in addition to their client, Richard Allen. Some of these priorities involve client conferences and scheduled hearings set during the week of February 5th, 2024. Furthermore, and number 8, furthermore, attorney Rosie is scheduled to be out of the state of Indiana on Monday, February 12th, 2024, which he wrote in his motion on personal matters. Number 9, any reasonable delay allowing for attorneys Rosie and Baldwin to get back up to speed, exchange discovery, communicate with defendant Allen, and review the new discovery would not be of any detriment to the state. Well, of course not, but they just don't want you to expose them, so they don't even want you to get the discovery back. I assume. I'm speculating. Number 10. On January 29th, 2024, defendant Allen filed his verified motion to disqualify and accompanying affidavit. The filing of a motion for disqualification and or request for recusal strips the court of any jurisdiction, I added that any, to decide on any matters until a ruling on the disqualification motion occurs. So she, like I said in the last video, she has absolutely no right at this time to be ruling on anything because the very first thing that needs to be ruled on is this disqualification. And whether Gull's going to be continuing on, I think they should disqualify Prosecutor McLeland too, if they can. But they definitely already tried to disqualify Judge Gull, and that motion is still pending. So that needs to be taken care of first and foremost before she can give any orders to the anybody in this case. So that's my understanding of it. The filing of a motion for disqualification strips and or request for recusal strips the court of jurisdiction, according to Lucas versus State. Therefore, it seems logical that the motion to disqualify would be fully adjudicated before any further hearings take place or before any further orders are issued by this court. Yeah, so stop issuing things, Gull, like immediately after Nick filed something, then she filed her motion denying all of the pending requests that Richard Allen's team had. So that was nice of her, with no reasoning either. Therefore, it seems logical that the motion to disqualify would be fully adjudicated. Sorry about that. Wherefore, attorneys Rosie and Baldwin respectfully request that this court continue the February 12th, 2024 hearing on the state's motion to amend charging information and reschedule the matter on a date and time convenient for all parties, and after a full and just adjudication on defendant Allen's verified motion to disqualify takes place. So they're saying you can't schedule this now because you don't have jurisdiction, so you need to reschedule it for a time later after the disqualification hearing takes place. If you're still our judge, then you can schedule it, but until then, why don't you just hold off, is what they're saying here. There was one more page. Oh, this was just the I certify copy. It was e-filed by Andrew Baldwin and Bradley Rosie. So that was the motion to continue the hearing where Nick McLeland wants them to be found in contempt of court. Some more filings that took place. Yes, this happened today. This morning at 8:30 a.m. we got a limited appearance on behalf of Bradley A. Rosie. So it appears now that Rosie has an attorney named David Hennessy who will be representing him. He enters a temporary and limited appearance for Bradley A. Rosie, appointed counsel for defendant, attorney information for services as follows. And then limited representation is to respond to allegations of contemptuous conduct. So that's what he's herefore undersigned counsel is cognizant of the court's concerns regarding public disclosures and pledges compliance. So that is on behalf of Brad Rosie, and we have the same exact document but for Andrew J. Baldwin. So David R. Hennessy is going to be representing them both for the allegations of contemptuous conduct. All right, moving on. We are almost done. There were several documents, but they're all really short, so that's good to know. This one is a motion to vacate hearing, and this one comes from I believe it was Andrew Baldwin. Yeah, Andrew Baldwin. All right, so motion to vacate hearing. This is just to get rid of the hearing altogether, he's saying. Comes now the accused by counsel and moves the court to vacate the February 12th, 2024 hearing. In support thereof, counsel states. So these are the reasons why. Number one, the defense filed a verified motion to disqualify on January 28th, 2024 at 10 p.m. That means this is in play first. And then shortly thereafter, so number two, the state filed a verified information for contemptuous conduct on January 29th. So a day later, not even 24 hours later, Nick McLean. Do you think Nick is maybe pissed at these guys and really wants them off the case? Because I think he had that document for the verified information for contemptuous conduct. I think he had that up his sleeve for a while. Sorry, I'm trying to straighten out my camera here. I think he had that document up his sleeve for a while, but he was just waiting for a moment to throw it out there and file it. And I think he was mad that the defense beat them to it with the motion to disqualify. Anyways, so the state filed a verified information for contemptuous conduct on January 29th, 2024 at 4:30 p.m. In the pleading, the state requested the court to issue rule to show cause, set a hearing, and order Mr. Baldwin and Mr. Rosie to appear and show cause. This has not been done. 3. Additionally, upon the filing for disqualification, the court was divested of jurisdiction, which means they no longer have it after the filing of their motion. Judge has no authority anymore to act in the case on any matter other than the motion for change of judge or emergency matters. So, according to this case, Wade versus Cass Circus Court, you're not allowed to do any kind of motions or anything unless it's an emergency or you're ruling on the change for judge. Number 4, on February 1st, 2024, the court set the state's request to amend the charging information and their allegation of contemptuous conduct for hearing on February 12th, 2024 at 9 a.m. Before the court takes any action on any motions, there should first be a hearing on the motion to disqualify. Bam. Straight up, simple, sweet. And you can't deny it because that's the law. Wherefore, the accused respectfully prays the court to vacate the February 12th, 2024 hearing and schedule a hearing on the motion for disqualification and for all other relief just and proper in the premises. Certified by Andrew Baldwin, respectfully submitted by Andrew Baldwin. So yeah, there's that. What do you guys think of this all going on? Do you think that Judge Gull is going to vacate the hearing and schedule a hearing for disqualification? Do you think she's just going to give a motion and say disqualified without any hearing kind of thing like she's done in the past? So what do you guys think? Let me know in the comments below. Please don't forget to like, comment, and subscribe. And I'm going to leave you on this funny note. Well, maybe not funny. I don't know how funny it is. I kind of thought it was a little funny. And I would never do this, but Someone pointed out on a Reddit page that judges have Google reviews, and people reviewed her very poorly. She's got a 1.6 Francis goal. And my guess is that some of these people are like, yeah, like because you're an observer of the Delphi case, you're rating her a 1, which I don't recommend doing. Please don't do that. But it is kind of interesting that a judge can be rated on Google. I thought that was kind of funny. Please go ahead, like this video, and I will see you next time. Take care. Thanks again for watching. Bye.